everyone. Today we're just going to continue our discussion with regard to family code, and the three topics that I'm going to discuss and what's assigned to me is that marriage of exceptional character, second is the void and voidable marriage, and the third one is the authority to solemnize marriage. Article 27. In case either or both the contracting parties are at the point of death, the marriage may be solemnized without necessity of a marriage license and shall remain valid even if the ailing party subsequently survives. So, meron mga kind ng pagkakataon or instances in which we could consider those two parties or dalawang couple na gusto magpakasal in which perhaps they in the middle of war or meron silang sakit, and then it could be considered na pwede pa din silang ikasal despite not having the license or the marriage license sa kailangan nila. So, even makasurvive man sila doon ay it would still be considered na valid yung marriage nila. Article 28. If the residence of either party is so located that there is no means of transportation to enable such party to appear personally before the local civil register, the marriage may be solemnized without necessity of a marriage license. So, isa ding pwedeng i-consider na pwedeng ikasal yung dalawang couple without them having the marriage license is that kapag ka masyadong malayo yung location nila, di ba merong mga instances dito sa Philippines in which there are different kind of areas in which masyado silang malayo sa kanilang local or sa municipality nila. So, in those kind of instances, it could still be valid, and then pwede natin i-consider na sila ay pwede pa din ikasal or that they can still proceed sa pagpapakasal nila even though wala pa sila ng mga requirements na kailangan nila. Article 29. In the cases provided for in the two preceding articles, the solemnizing officer shall state in the affidavit executed before the local civil registrar or any other person legally authorized to administer oaths that the marriage was performed in articulo mortis, or that the residence of either party specifying the barrio or barangay is so located that there is no means of transportation to enable such party to appear personally before the local civil registrar, and that the officer took the necessary steps to ascertain the ages and relationship of the contracting parties and the absence of legal impediment to the marriage. So there are different kind of instances, like we've mentioned kanina, that maybe those two couples na gustong magpakasal is that malayo sila masyado sa local area nila. And then here naman sa Article 29, we are mentioning about those kind of instances na wala namang available transportation, especially in those areas sa mga provinces, ganyan. So, hindi available yung mga transportation nila as all times. And it was also mentioned here na dapat as it was performed or that the marriage was performed in articulo mortis, or that they're in the point of death, or that either or maybe both or parehas na parties are in the point of death. So there are those kinds of instances na if they still wanted to get married, they can still proceed with that. And then of course, they should specify or that after that is merong affidavit or isang letter na nagpapatunay or that the authorized person who na nagkasal sa kanila ay merong maipaprovide na affidavit. Katunayan na sila ay talagang ikinasal by that given time or date. And in Article 30, the original of the affidavit required in the last preceding article, together with a legible copy of the marriage contract, shall be sent by the person solemnizing the marriage to the local civil registrar of the municipality where it was performed within the period of 30 days after the performance of the marriage. So, will be given 30 days for them to pass the marriage contract by the solemnizing or kung sino nga ba yung nagkasal sa kanila, in which it will be provided or that it will be given to the municipality in order for them to be registered. Kasi diba, hindi naman magiging recognized isang municipality that the two couple were already married or that they're naganap na yung pagpapakasal sa kanila without them passing the contract na pinarmahan na nila. And then, in Article 31 naman, a marriage in articulo mortis between passengers or crew member may also be solemnized by a ship captain or by the airplane pilot, not only while the ship is at sea or the plane is in flight, but also during stopovers at ports of call. So, meron mga pagkakataon that there are those kinds of couples na siguro either were stranded in the middle of a kind sa mga pagta-travel nila, say for example, and then parang naabutan sila that they don't have any choice but to be married in that exact moment. So they can ask either yung pilot na sinasakay nila or the ship captain, in which they are also authorized person para magkasal sa dalawang married couple who wanted to get married at that time of napili nila, or that may mga instances lang din talaga na maybe we cannot stop it, and then it was still included in our code naman, in our family code, na they can still be recognized or that valid yung mga ganong kind of situations. And then, Article 22, a military commander of a unit who is a commissioned officer shall likewise have authority to solemnize marriages in articulo mortis between persons within the zone or military operation, whether member of the armed forces or civilians. So, even in this kind of cases, binibigyan din ng authority yung ating mga commander or those na mataas yung position in the military service, in which may mga pagkakataon na maybe in the midst of war, yung either the civilians or pwede ding mga armed forces or yung officer nila mismo or the military itself ay gusto magpakasal in that exact moment kasi maybe everything was way too chaotic na or that masyado nang magulo yung war, ganyan. But at the end of the day, they still wanted to get married. So, they have the authority or they can still proceed with the marriage. Or that, after that, makasurvive man sila is that valid pa din yung naging kasal nila na naganap by that time. And then in Article 33, marriages among the Muslim or among members of the ethnic cultural communities may be performed validly without the necessity of marriage license, provided that they are solemnized in accordance with the customs, rites, and practices. So it was mentioned here yung mga kapatid nating Muslims in which they have their own kind of culture and then they have their kind of mga rules na fina-follow. And then with that kind of instances ay nagiging valid pa din yung pag-perform nila ng mga marriages. Meron din mga instances na it was totally different with the kind of mga nakasanayan natin in which kasama nga doon that yung pwede sila magpakasal ng more than isa yung asawa nila, ganyan. So, yung mga ganong kind of culture for them is still acceptable naman. Kasi it's a way of showing respect for them and also to show na sinusunod yung kanilang kind of rule na meron sila under their culture. And then in Article 34, no license shall be necessary for the marriage of a man and a woman who have lived together as husband and wife for at least 5 years and without any legal impediment to marry each other. The contracting parties shall state the foregoing facts in an affidavit before any person authorized by law to administer oaths. The solemnizing officer shall also state under oath that he ascertained the qualifications of the contracting parties are found no legal impediment to the marriage. Here in the Philippines is masyadong common sa atin in which there are those two couples who have lived already sa isang bahay or sa isang roof. And then kapag they have provided naman sa mga authorized person that they were together for more than or at least 5 years, they are authorized or that they can still proceed to their marriage. And then, magpo-provide lang din sila ng mga affidavit in which it will state na sila ay ganun nakatagal, ganyan, and then the other requirements as well that was needed for them to comply. And then after that, is pwede na sila mag-proceed to the other steps na dapat nila makompleto for them to be recognized as a married couple. First, the Article 35, in which the following marriages shall be void from the beginning. First, those contracted by any party below 18 years of age, even with the consent of parents or guardians. So, they should know that ang age ng mga taong papakasal is still be considered, in which kapag minor pa sila, they should have the consent of their guardians or parents. And the next naman is those solemnized by any person not legally authorized to perform marriages unless such marriages were contracted with either or both parties believing in good faith that the solemnizing officer had the legal authority to do so. So, yung mga nagkasal dapat sa kanila, they should have the authority to do so or that authorized person sila para mag-conduct ng isang marriage. Kasi if not, hindi ma-recognize yung kanilang marriage. So, or after that is hindi pa rin sila ma-consider as married couple. And then for the third one, those solemnized without a license except those covered by the preceding chapters. So kanina we've discussed about different kind of mga pwede nating i-consider, such as yung transportation or yung area ng mga gusto ikasal. Kapag masyado silang malayo or that there is no available transportation, they can proceed or they can still get married. Pero there's still those kind of instances na kapag wala namang valid license or any requirements that was needed na kailangan nilang i-comply and then hindi nila yun nagawa, is that hindi sila makakapag-proceed sa kanilang pagpapakasal. And then the fourth one, those bigamous or polygamous marriages not falling under Article 41. So we mentioned din kanina about the Muslims or those cultures na inaalaw sa kanila yung magkasal ay yung authorized person from their tribes or mula dun sa kultura nila. So, there are different kind of instances din na kapag hindi ka part ng culture na yon or that you are not included in the certain kind of religion na mag-conduct ng polygamous or bigamous in which ay pwedeng magkaroon ka ng 2 or more na husband or na wife, ay hindi papayagan na magpakasal. So the fifth one naman, those contracted through mistake of one contracting party as to the identity of the other. Before getting married, we should also know that those informations na alam natin about our partner or the person that we're going to get married with are real, or that it is from the truth, or their identity are all written na tama yung lahat ng mga nakalagay doon. And then for the sixth one naman, those subsequent marriages that are void under Article 53. 26. A marriage contracted by any party who at the time of celebration was psychologically incapacitated to comply with the essential marital obligations of marriage shall likewise be void even if such incapacity becomes manifest only after its solemnization. The action for declaration of nullity for the marriage under the article shall prescribe in 10 years after the celebration. So, there mga pagkakataon din na maybe one of those party ay nagkaroon ng problema in terms of psychological nila. So, hindi sila nagkakaroon ng, or that they are not capable enough to handle certain kind of obligations under the marriage. So, pwedeng ma-void siya, or pwedeng pawalang visa yung kasal nila after that. So, dapat as after 10 years ng celebration ng pagpapakasal nila, they are both fine, or that walang magiging problema sa kanila psychologically or other terms na kanilang well-being. Article 37, marriages between the following are incestuous and void from the beginning whether the relationship between the parties be legitimate or illegitimate. First, between ascendants and descendants of any degree, and second, between brothers and sisters, whether of the full or half blood. So, it was really common here in the Philippines that everyone have already know this. And then, madalas din na napapaalalahanan tayo ng mga nakakatanda na bawal ikisal ang taong merong relationship or that they are relatives. 'Di ba? Kasi parang though it was common sa ibang bansa kasi it's a way for them to preserve yung culture nila, and at the same time para mapanatili yung yaman ng isang pamilya. But here in the Philippines, it was void, or hindi dapat binibigyang visa ang pagpapakasal ng mga taong merong isang relasyon sa isa't isa as relatives, or that they are brothers and sisters, and kahit sila ay half or full blood pa. And then Article 38, the following marriages shall be void from the beginning for reasons of public policy. So ito naman yung mga mapapawalang bisang mga kasal depending on, first, between collateral blood relatives, whether legitimate or illegitimate, up to the fourth civil degree. Second, between step-parents and step-children, between parents-in-law and children-in-law. Fourth one is between the adopting parent and the adopted child, between the surviving spouse of the adopting parent and the adopted child, between the surviving spouse of the adopted child and the adopter, between the adopted child and a legitimate child of the adopter. 8, between adopted children of the same adopter. And 9, between parties where one of the intention to marry the other killed that other person's spouse or his or her own spouse. So, it was also mentioned here that though merong mga anak that they are just adopted, they're still not allowed na magpakasal pa din dun sa anak nila or dun sa parents nila na nag-adopt sa kanila. Kasi legally, it would be considered that they already have the relationship and that they should maintain having that kind of relationship. So, it was mentioned here as well sa pinakalas yung part na kapag yung intention ng isang tao na pagpapakasal is to kill the person's spouse, yung asawa ng isang tao, is that walang visa din yun. Kasi we already know that there is that hidden intention kung bakit nga pong papakasal yung dalawang taong yun. And then in Article 39, the action or defense for the declaration of absolute nullity of a marriage shall not prescribe except as provided in Article 36. So, here naman, kapag na-mention natin kanina sa 36 about psychological incapacitated ng isang tao, dapat sila ay psychologically capacitated na mag-handle ng isang relationship. And then, in Article 40, the absolute nullity of a previous marriage may be invoked for purposes of remarriage on the basis solely of a final judgment declaring such previous marriage voided. So, if you wanted to get married again, and then parang you have the history na meron ka na napakasalan, you have to clean that kind of record na meron ka muna. Of course, you have to prove na you was not married or that hindi void or walang visa yung kasal mo before in order for you to proceed into another marriage you wanted to go through, or that to be married dun sa another person na gusto mong pakasalan. And then in Article 41, a marriage contracted by any person during the subsistence of a previous marriage shall be null and void unless before the celebration of the subsequent marriage the prior spouse had been absent for 4 consecutive years and the spouse present had a well-founded belief that the absent spouse was already dead. In case of disappearance where there is danger of death under the circumstances set forth in the provisions of Article 391 of the Civil Code, and absence of only 2 years will be sufficient. So, it could be also reported then na pwedeng ma-void or mapawalang bisa ang isang kasal kapag ka napatunayan na yung taong pinakasalan mo is absent, or that hindi naman siya palaging nasa iyo, or that maybe there are different kind of circumstances then na was given, and then pwede ka mag-report on that para mapatunayan mo na hindi mo laging nakakasama yung pinakasalan mo, ganyan, or that and the consecutive years ng pagsasama nyo as it has always been you and you never felt that someone na pinakasalan mo. And then in Article 42, the subsequent marriage referred to in the preceding article shall be automatically terminated by the recording of the affidavit of reappearance of the absent spouse unless there is a judgment annulling the previous marriage or declaring it void. So, it could also be automatically terminated. Depende din sa mapaprovide na affidavit in which is mapapatunayan na nagpakita naman after you say na hindi na nga, or there's a disappearance to your spouse, and then it was provided that there is an affidavit or a document that says na merong reappearance or that nagpakita ulit siya sa'yo. So, it could be recognized again, and then here reappearance of the absent spouse unless there is a judgment annulling the previous marriage or declaring it void. So, you have the rights para i-confirm if there is an annulment or that nawalang bisa yung previous marriage mo. Article 43, the termination of subsequent marriage referred to in the preceding article shall produce the following effect. First, the children of the subsequent marriage conceived prior to its termination shall be considered legitimate, and their custody and support in case of dispute shall be decided by the court in a proper proceeding. So, if there would be that instances that the two married couple chose or decided that they would be separated, of course, the custody of the child, or kapag nagkaanak sila, then it will be decided by the court kung paano nga ba yung magiging obligation nila toward their child. And then legitimate pa din na pwedeng ang gamitin pwedeng apelyido nung anak nila is whatever they chose to. Especially here in the kind of system na meron na tayo here in the Philippines, in which we're allowed to choose kung ano nga bang apelyido yung gagamitin ng anak natin, either to the side of the parent or maybe in the side of the father. Number 2, the absolute community of property or the congenial party, as the case may be, shall be dissolved and liquidated, but if either spouse contracted said marriage in bad faith, his or her share of the net profit of the community property or conjugal partnership property shall be forfeited in the favor of the common children, or if there are none, the children of the guilty spouse may be by the previous marriage, or in default of the children, the innocent spouse. So, if it was decided by the two couple na magsaseparate na sila, of course, the division or yung pag-separate nila ng mga net profit nila would still be to consider. Kasi syempre, malalaman natin kung alin nga ba yung dapat na mapasa kanya and mapasa other side in order for them na maging fair yung lahat ng hatian after that na magsa-separate na sila. And then the third one naman, donations by reason of marriage shall remain valid except that if the donee contracted the marriage in bad faith, such donation made the said donee are revoked by operation of law. So, pwedeng makancel ang mga donation na meron sila if it depends dun sa gusto mag-donate, of course, to the couple, kung itutuloy pa ba nila or not, and then it could still be valid naman sa kanila na ituloy pa din siya. And in the fourth one naman, the innocent spouse may revoke the designation of the other spouse who acted in bad faith as a beneficiary in any insurance policy, even if such designated be stipulated are irrevocable. spouse who contracted the subsequent marriage in bad faith shall be disqualified and inherent from the innocent spouse by testate and in intestate succession. So, meron mga pagkakataon that the reason of why they're going to separate is that meron ng mga physical abuse or that they have the reason for them to do separation, such separation. So, kapag mayroong mga ganong instances, it would still be considered na titingnan kung ano nga ba yung qualification and disqualification of the said couple na para ma-inherent nila yung mga meron na sila or that mga na-invest nila in the prior na kanilang marriage. So, it could still be decided kung qualified ba yung isang tao or karapat-dapat pa bang matanggap niya yung mga dapat niya matanggap or not. Kasi it's either they have violated certain kind of law or that they have violated yung rights ng isa't isa. And then Article 44, if both spouses of the subsequent marriage acted in bad faith, said marriage shall be void ab initio, and all donations by reason of marriage and testamentary disposition made by one in favor of the other are revoked by operation of law. So, hindi lang naman possible na isa lang yung nagkakamali sa isang married couple. So, there would be instances in which pareho sila na merong bad faith or that they both had did something wrong. So, it could still be seen naman or could still be considered if sila man dalawa ay dapat na karapat-dapat pa din doon sa mga dapat nilang matanggap. And of course, there would be testaments na nagpapatunay ng mga ginawa nila. And there would still be proceedings with regard to that. And in Article 45, a marriage shall be may be annulled for any of the following causes existing at the time of the marriage. So, though here in the Philippines, it was not considered or hindi sa atin yung about sa divorce, meron naman sa ating annul. So, it was a different process in which perhaps it would be more complicated lang din kapag ka-annulment yung they have to go through. And in the first one, that the party in whose behalf it is sought to have the marriage annulled was 18 years of age or over but below 21, and the marriage was solemnized without the consent of the parent, guardian, or person having substitute parental authority over the party in that order, unless after attaining the age of 21, such party freely cohabited with the other and both live together as husband and wife. So, it was mentioned kanina that if those two couple na gusto magpakasal ay below minor or that they are still minor, they need the consent muna ng mga magulang nila. And then second one, that either party was of sound mind unless such party after coming the reason freely cohabited with the other as husband and wife. Third, that the consent of either party was obtained by fraud unless such party afterwards with full knowledge of the facts constituting the fraud freely cohabited with the other as husband and wife. So, of course, marriage could also be a kind of fraud or pandadaya ng isang tao para magawa niya yung isang bagay na gusto niya or that there's that hidden intention kung bakit niya gusto magpakasal toward another one. And the fourth one, that the consent of either party was obtained by force, intimidation, or undue influence unless the same having disappeared or ceased, such party thereafter freely cohabited with the other as husband or wife. So if the two married couple decided to get married, of course there should be no force or walang sapilitan. It should be like freely or that they really wanted to do that. And then fifth naman, that either party was physically incapable of consummating the marriage with the other in such incapacity continue and appear to be incurable. So, of course, kapag nakikita natin na parang there's that kind of physical incapability na yung partner natin, the marriage could still be void given na hindi na pwedeng maggamot yung kind of physical incapability na meron sila. And then sixth naman, that either party was afflicted with a sexually transmissible disease found to be serious and appeared to be incurable. So, if you found out that your spouse or that the person you married to have this kind of transmissible disease na hindi na siya pwedeng ma-cure, is that you can still file or that your marriage could still be void or mapawalang visa. Given na, say for example, they might have an AIDS or HIV or any kind of disease na nakuha nila. And in 46, Article 46, any of the following circumstances shall constitute fraud referred to in the number 3 of the preceding article, First, non-disclosure of a previous conviction by final judgment of the other party of before getting married to someone, we should also know the previous conviction nila or that tapos na ba or meron na bang closure yung kind of conviction na meron sila before or that tapos na ba yung mga kailangan nilang kaharapin kaso, this and that, para maging clear na lahat and that your marriage won't be void. And then second naman, concealment by the wife of the fact that at the same time of the marriage, she was pregnant by a man other than her husband. So, kapag ka naman in case sa mga babae, and that person was pregnant, and then yung asawa, hindi, yung papapakasalan niya is hindi yung ama nung dinadala niya, is that the marriage could still be void, considering that the husband found that, or natagpuan, or nalaman nung papakasalan niya yon. So, there would be that kind of cases, pero good thing is, perhaps, that would be just like, bihira lang din naman siya. And then third naman, concealment of a sexually transmittable disease regardless of its nature existing at the time of the marriage. So if you were already married and then you found out na meron siyang transmissible disease and that pwede ka pwedeng mag-request na you don't want it to continue that kind of relationship or that you want it to be annulled by that person you married to. Fourth, concealment of drug addiction, habitual alcoholism, homosexuality or lesbianism existing at the time of the marriage. So, here in the Philippines is that hindi pinapayagan sa atin yung same-sex marriage and then there could be still some kind of instances in which we can consider kung alin nga pa yung mga dapat na void marriage in which kapag ka nakikita natin that perhaps our partner or our spouse have this drug addiction, habitual alcoholism. So you can also reconsider that if you wanted to still be married to that person or that you wanted to be annulled with them or you wanted to separate with them. Article 47, the action for annulment of marriage must be filed by the following persons and within the periods indicated herein. So if you wanted to be annulled by the person you get married to, and then you have to follow this kind of actions. First, for cause mentioned in number 1 of Article 45 by the party whose parent or guardian did not give his or her consent within 5 years after attaining the age of 21 or by the parents or guardian or person having legal charge of the minor at any time before such party reaches the age of 21. So we have to be sure about our age because it really matters if we're going to get married. Of course, we have to get the consent of our guardians or our parents. So it was very common tradition here in the Philippines as well, in which before getting married, we first asked the consent of our guardians or parents. Though it has been always be parang naging tradition na din siya. And then at the same time, it's a way of showing respect to them as well. And then later on, para makita din natin na they have the support or we have the support din nanggagaling from them. And then second naman, for causes mentioned in number 2 of Article 45, by the same spouse who had no knowledge of the other's insanity, by any relative, guardian, or person having legal charges of the insane, at any time before the death of either party or by the insane spouse during a lucid interval or after regaining sanity. Of course, nakikita din natin dito sa pagpapakasal if the person that we get married to is sane or insane. Nasa maayos ba silang pag-iisip or nasa katinoan ba sila? Of course, it's one thing that we have to consider kasi of course, we're going to be with them for the rest of our lives. And then, isa din yun sa bagay na dapat natin i-consider if they have the knowledge ba kung bakit ng pagpapakasal nila or that alam nila sarili nila that they chose to get married or that nasa decision talaga nila yung pagpapakasal. And then third naman, for causes mentioned in number 3 of Article 45 by the injured party were within 5 years after the discovery of the fraud. For causes mentioned in number 4 of Article 45 by the injured party were in 5 years from the time of the forced intimidation or undue influence disappeared or ceased. 5 for causes mentioned in number 5 and 6 of Article 45 by the injured party within 5 years after the marriage. So, Article 48, in all cases of annulment or declaration of absolute nullity of marriage, the court shall order the prosecuting attorney or fiscal assigned to it to appear on behalf of the state to take steps to prevent collusion between the parties and to take care that evidence is not fabricated or suppressed. Of course, if you're going to be annulled by the person you get married to, you have to make sure that you have the evidences or that kasama nga ba siya sa mga dapat na i-consider if you're going to be annulled by the person you married to. And of course, there should be a presence din ng mga attorney nila para ma-provide yung mga evidences na sinasabi and the documents na dapat nilang i-present sa korte. And then 49 naman, during the pendency of the action and in the absence of adequate provisions in a written agreement between the spouses, the court shall provide for the support of the spouses in a custody and support for their common children. The court shall give a paramount consideration to the moral and material welfare of said children and their choice of the parent with whom they wish to remain as provided for the Title 11. It shall also provide for appropriate visitation rights of the other parents. So, of course, kapag the two married couple chose na that they would be separated, one thing na kailangan kina-consider is that yung naging anak nila. Of course, kung kanino nga bang custody and the kind of support that they needed to provide para makita pa din natin that masecure pa din natin yung bata and that magkaroon pa din ng maayos na future yung bata. And of course, there will be provided documents naman and kung ano nga ba yung mga dapat nilang sundan in case na kung kanino mapupunta yung custody ng bata. And then, pwede namang magbigay ng visitation rights doon sa another parent. And then sa Article 50, the effect provided for in the paragraphs 2, 3, 4, and 5 for Article 43 and in Article 44 shall also apply in proper cases to marriages which are declared void ab initio or annulled by final judgment under Article 40 and 45. Article 51, in said partition, the value of the presumptive legitimes of all common children computed as of the date of the final judgment of the trial court shall be delivered in cash, property, or sound securities, unless the parties by mutual agreement judicially approved had already provided for such matter. Of course, they should still provide the kind of obligations and responsibilities na dapat nilang ibigay dun sa anak nila. Kasi, despite being separated, known that once for a while, they have child, and then, kasama dun sa pagiging married nila, or that kasama dun sa journey nila as married couple is that they have somewhat a blessing, or meron silang anak. And then Article 52, the judgment of annulment or an absolute nullity of the marriage, the partition and distribution of the properties of the spouses, and the delivery of the children's presumptive legitimacy shall be recorded in the appropriate civil registry and registries of property, otherwise the same shall not affect third person. Of course, kailangan din nilang mapagdesisyonan kung ano nga ba yung mga dapat na partition and distribution of the property ng spouses nila, kung kanino mapupunta yung mga na-invest na nila or the properties that they already have upon getting married to each other. And then Article 53, either of the former spouses marry again after complying with the requirements of the immediately preceding article, otherwise a subsequent marriage shall be null and void. Of course, before you chose to get married into another person, you have to first secure na dapat is void na or that wala ng visa yung kasal mo before. Para hindi ka din makasuhan or that wala ng other maging sagabal pa or other problem that it may cause. And then Article 54, children conceived or born before the judgment of annulment or absolute nullity of the marriage under Article 36 has become final and executory shall be considered legitimate. Children conceived or born of the subsequent marriage under Article 53 shall likewise be legitimate. Of course, legitimate pa din yung magiging anak nila even kasi it was considered na bago pa naman sila i-annul or bago pa naman mapawalang visa yung kasal nila is meron na silang anak. And now we are going to proceed with the authority to solemnize marriage, in which we're going to know who are those persons who are authorized na magkasal sa dalawang tao. The Family Code provides an exclusive enumeration of persons authorized to solemnize marriage in the Philippines. Among the formal requisites of a valid marriage is the authority to solemnizing officer, the person who officiated over the marriage ceremony. The contracting parties must personally appear before the solemnizing officer. The absence of any of the former requisites render the marriage void from the very beginning. Subject to petition for declaration of nullity of marriage. The following are the persons authorized to solemnize marriage. First, any incumbent member of the judiciary within the court's jurisdiction. So, under our judiciary, ay pwede din sila magkasal and which pwede yung maganap inside the court. Second, any priest, rabbi, imam, or minister of any church or religious sect duly authorized by his church or religious sect and registered with the Civil Register General, acting within the limits of the written authority granted by his church or religious sect, and provided that at least one of the contracting parties belongs to the solemnizing officer's church or religious sects. So here in the Philippines naman is, alam natin na kapag kasi for example sa mga Muslims, pwede na under yung religion nila, yung may authorized person sila na magkakasal, and then sa Christians naman, it could be the priest, and dapat yung isa sa taong ikakasal or that one of those party ay other ng religion na yun para makonsider din siya na may visa yung kasal nila or that pwede silang ikasal dun sa certain religion. Third, any ship captain or earthling chief only in the case of marriage in articulo mortis at the point of death between passengers or crew members, not only while the ship is at sea or the plane is in flight, but also during stopovers at ports or off call. So there could be certain kind of instances na merong mga unexpected happenings or that it could be something worse or something na pwedeng masamang mangyari. So in that kind of situations, if those two couples wanted to get married, ay pwede din silang mag-ask ng solemnizing officer. So it could be kapag kasi for example nasa airplane sila, so they could ask the pilot or the captain nung sinasakyan nila ngayon, or maybe it could also be applicable then kapag ka nasa dagat or sa ship yung dalawang couple. So it could be considered based on sa articulo mortis in which the two couple should be given na sila ay in the point of death. And then number 4 naman, any military commander of a unit to which a champlain is assigned in the absence of the latter during a military operation only in marriages celebrated in articulo mortis at the point of death between persons within the zone of military operation were members of the armed forces or civilians. So here naman, pwede din magkasal yung mga commander or the military commander of a certain kind of military. Kasi meron mga pagkakataon na maybe they are in the midst of war and then masyado ng chaotic yung lahat and then they still wanted to get married and pwede nilang ma-ask yung solemnizing officer na yun para ikasal sila. So, it could be applicable parehas kapag ka if the person is part of the armed forces or even if sila ay civilian lang. And then fifth naman, any consul general, consul or vice consul in marriages between Filipino citizens abroad, the issuance of a marriage couple license and the duties of the local civil registrar and of the solemnizing officer with regard to the celebration of marriage shall be performed by said consular official. So, yung mga consul general natin ito is pwedeng, they're considered as a government official in which pwede siyang maghanap. Say, for example, the two couple are in the other country and then nadun din yung consul general na yon, consul or vice consul, ay authorized person din sila na mag-solemnize na isang marriage. So, pwede maganap yung marriage nyo even you are in the other country and then merong present na government official in that certain country where you are in. Notwithstanding the absence of the authority of the solemnizing officer, the marriage may be valid if it was contracted with either or both parties believing in good faith that the solemnizing officer had the legal authority to do so. Of course, before you consider na you are going to get married, you also have to know if yung tao nga ba na magkakasal sa inyo is authorized person para may visa pa din yung magiging kasal nyo or that it would be still recognized. That is the end of my report. I hope that you learned something and maybe maalala lang din yung mga bagay na dapat nating matandaan, especially yung mga tao na dapat magkasal sa dalawang couple and ano yung mga pwede nating makonsider in order for us na may visa nga ba yung magiging kasal natin or wala. Of course, there are different kind of things that we have to consider before getting married, and of course, it's something that we have to treasure as well and to give value to. So that would be all again. This is Jonathan Cabase, and this is the end of my report. Thank you so much.